everyone. Welcome to another episode of our podcast, and welcome again, Lory. We're thankful for your presence.
Glad to be here. It's always fun to do a podcast with you.
It definitely is. And today is a very exciting topic, something of great importance to many of our clients. And really, it's a case that really got me excited about practicing immigration. And we're going to talk about Padilla versus Kentucky. It was a Supreme Court case that really raised the awareness and the importance of criminal defense counsel being able to make sure that non-citizen clients are aware of the immigration consequences of their cases. And Lory is going to tell us a lot more about that case and what it means for our clients. But essentially, if that wasn't done, in many cases, clients have been able to reopen their cases. If the criminal defense attorney either didn't advise or didn't get the proper help to be able to advise the non-citizen client about those consequences, in some cases we can reopen it. And we'll have a discussion today, but essentially it's a very daunting task for criminal defense attorneys to be able to do this because as you start practicing law, you really become specialized in one area of the law. And even one area of the law has many sub areas where you can really niche down and be specialized. So it was very daunting for criminal defense attorneys to have this responsibility, but luckily we've had people like Lory and other organizations really help public defender offices and help criminal defense attorneys understand this and comply with their responsibilities under Padilla. But Lory, take it away. Tell us a little bit about the case and the implications it's had since then.
Okay, great. So the case is a Supreme Court case, Padilla versus Kentucky, and it was decided in 2010. It was argued actually in 2009, decided in 2010. And the Supreme Court making decision ruled that unlike other state consequences of a guilty plea, such as losing the eligibility to be licensed in the state, losing the ability to vote if you were convicted of a felony, and being unable to register to carry a handgun, and some other consequences that were state consequences, the deportation consequences of a guilty plea were so extreme and so inextricably tied into the conviction itself that it really triggered a Sixth Amendment protection, meaning that as part of the Sixth Amendment right to counsel, a defendant also had a right to counsel being effective in telling them, advising them of the immigration consequences of taking a guilty plea. Now, that doesn't mean that the charge had anything to do with immigration. The charge could be anything. It could be aggravated assault. It could be bank robbery. It could be some type of financial crime. It could be a domestic violence crime. Any type of crime potentially has immigration consequences. After the IRA in when was IRA?
It might be 96, if I had to guess.
1996, taking effect in April 1997 for the most part. After that, the aggravated felony penalties and other criminal penalties became so broad that almost any kind of a conviction could result in deportation. And when it was an aggravated felony, that meant that there were hardly any or no forms of relief that a convicted defendant could get in the immigration and deportation context. So that meant that if someone took a plea to plead guilty to a crime that would be classified as an aggravated felony offense, that person had basically signed their own deportation order. And so if their defense counsel, public defender, private defense counsel, did not warn them before taking that plea of these potential consequences that were 99% likely, then that person had not been advised in an effective manner. And maybe they would not have taken that plea. They might have tried their chances at trial, for example. So as Felipe said, if the 2010 decision, which applies to everybody since 2010, if that was not followed, and if defense counsel did not warn their client, the defendant, of the possibility that this crime might be construed as an aggravated felony, and as a result, it would lead to an almost absolute order of deportation, then it would be possible potentially to reopen that case, not in immigration court, but in criminal court, and in the state court or the federal court, but generally the state court where the defendant was convicted. And you can claim that you had ineffective counsel because your counsel never advised you or told you about the potential immigration consequences. And usually, and that's, for example, the reason that's a very, very good basis to reopen your case is that, number one, it's a constitutional violation. And number two, it's something that later, if you manage to reopen your case, and if you manage to either vacate that plea or substitute another plea, if the prosecutor still wants to try you with another charge, that means that you can possibly avoid the aggravated felony, and it means that the immigration judge and Board of Immigration Appeals later will respect that vacation of judgment, because it won't have been done to avoid the immigration consequences, even though, in fact, that will be the result. It will have been done to cure the ineffective assistance of counsel and violation of Sixth Amendment right to counsel that occurred at the state level. So that's a critical reason why these ineffective counsel Sixth Amendment claims in the criminal defense context are so important.
So, Lory, let me see if I can recap. So, as citizens or non-citizens living in this country, we have a constitutional right under the Sixth Amendment to counsel, but we have the right to effective counsel, right?
Right.
And one of the things that would make criminal defense counsel ineffective is if he or she fails to advise me, the non-citizen, of the immigration consequences of my plea, of my case, etc. And so where would criminal defense counsel even look to know what is deportable or not, right? I started my career at a public defender's office. I was a public defender, so I took on criminal cases, but I received a fellowship and I got training on crimmigration. In fact, the first time I saw this word was when I read Padilla versus Kentucky. Criminal immigration became crimmigration. How cool was that?
Right.
And so it was my job to advise the office, essentially. And it was such a daunting task for my criminal defense colleagues to understand this. And, I can only imagine what it was like to all of a sudden be told that you had to advise. And wow, where do I even look to know if something is deportable, aggravated felony? Like, where do I find this stuff, Lory?
Right. And, the thing is, for better or for worse, that's still true today, more than 10 years later. Criminal defense counsel, and particularly public defender offices, they are so overwhelmed with the volume of criminal cases that they have to handle, that to them, it's a real burden in a way to have, if they had to do research and look into what would be the impact, for example, of aggravated assault under the statute in their state, or what would be the impact of criminal mischief, for example, maybe not such a severe, serious crime, but still it could carry immigration consequences. So you're asking, how would they know? I think it's really interesting to note that the burden here is being placed on criminal defense counsel. And that's because it follows under the Sixth Amendment. I often have asked myself, why isn't it the judge's duty to let the criminal defendant know, if you plead to this, if I accept your plea, what you're doing is pleading to something that is likely to be construed later by immigration officers as an aggravated felony. Are you aware of that? Are you voluntarily entering this plea, even knowing that? but it's not the judge's duty, and it's not the prosecutor's duty. And the only thing, there were cases prior to Padilla versus Kentucky, and they still exist today. It varies state by state, but there are cases in which you want to avoid, if you have a prosecutor who, for example, made promises. If a prosecutor affirmatively said, I'll give you this plea and you won't have to worry about immigration. If they affirmatively, that's what's looked at, whether they affirmatively advise you, or if in some cases, if the criminal court judge advises you of the same, take this plea, you'll be doing yourself a favor, blah, 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 no immigration problems. That is a basis also to try to reopen a case after the fact.
Interesting. So it's not their duty to advise you, but if they give you affirmative bad advice,
right,
then it could be a basis.
Right, affirmative misadvice. And actually, there are other Supreme Court cases. For example, I'm not going to give citations for this, but people can look them up. One is Lafler versus Cooper. Another one is Missouri versus Fry. And these cases and some other Supreme Court decisions are about people who went to trial or were advised to go to trial by an incompetent or ineffective counsel or by a prosecutor, and where somebody gets misadvice from their own defense counsel. If they go to trial because the attorney says they're not going to be able to prove X or Y, no problem, you go ahead and go to trial and it'll be dismissed. That kind of misadvice also can trigger, after the fact, a vacation of that judgment. So those cases are also interesting ones to read, but they're not exactly the Padilla case, and they don't impose the kind of duty that is imposed by the Supreme Court in Padilla on defense counsel to be the ones to know enough about immigration law to know, that could be an aggravated felony. So what's happened, you mentioned before that a lot of immigration advocates and immigration attorney groups have gotten involved, and there are actually organizations that have put their advocates into public defender offices. And some public defender offices, especially the forward-looking ones and the ones that could afford it, have on staff right in their office an immigration specialist. So in those cases, if you're a public defender in an office like that, that alleviates to some extent the duty of the public defender to do all the research and figure out whether or not the crime charged is one that's going to lead to deportation. And that immigration specialist can offer plea substitutes to the public defender that may in fact be ones that a prosecutor would accept and that then would not result in immigration consequences. So it's really important to take advantage of that. That should cut out some of the burden on criminal defense counsel. But I don't want to suggest that criminal defense counsel do not carry a burden. They do, because it's so important in plea bargaining, which is, I don't know the percentage, but a very high percentage of how criminal cases are resolved in this country now, that plea is one that has been properly analyzed by somebody. Public defender bears that burden under Padilla, but if there's an immigration specialist, or if the public defender or a private defense counsel wants to contract with an immigration office, an immigration practitioner's office, like your firm, for example, you could come on board and advise that defense counsel about the likelihood, what would be the problem, which type of immigration violation might that be considered, which ones wouldn't, what's an alternative plea that for sure would not, and you can look up immigration cases to make that determination. So it's a really good teamwork possibility when criminal defense counsel calls upon immigration defense counsel to work together in getting a plea that the prosecution will accept.
So if you're watching this and you're a non-citizen and you have a criminal defense attorney, but he or she is not familiar at all or vaguely familiar with immigration law, you need to get in touch with someone, with an immigration attorney that has this knowledge to make sure that you're making the right decisions. Lory, I don't know if you know this. So after my stint at the public defender's office, I had been trained by a mentor who was an expert in crim im. And she worked for the New York State Defenders Association.
Mhm.
She was a statewide director of that program. And then, one day she's like, I accepted a new position. I'm like, oh, wow, we're really going to miss you. And she goes, I want you to replace me. I'm like, I'm 2 years out of law school. You've been doing this for 2 years, because she would help criminal defense attorneys across the state of New York, and either other states would call her hotline, and she would help them. And so I took on that position, and I manned the hotline 2 years out of law school, and I would travel the state of New York and go to the public defender's offices, and even private practitioners would give us a call. And my Bible was a big fat red book that was written by Lory. So I don't know if I ever told you that, but
no, you didn't.
okay, there we go. Yeah, so my Bible was a book written by Lory, big fat red one. I still have it.
It's really challenging, it's a really challenging area. Honestly, I did not know that much about crim im. At the time we wrote that book, I had a co-author, but when we wrote it, actually I learned so much just from having to do the research and then applying that research and principles to these case situations, that by the time I finished writing it and it came out, I was pretty much an expert in the area.
No doubt.
And I've been attempting, honestly, Felipe, I've been attempting for the past 30 years to train public defender counsel, criminal counsel, private criminal counsel, to understand the immigration consequences, because they're so critical. And after the case is over and the plea is entered and it's on the books, it's not that easy to go back post-conviction and change it. And what I alluded to earlier is that in the immigration context, the case law issued by the Board of Immigration Appeals has been whittling away at the possibility that individual respondents in removal proceedings can actually change either the conviction itself or the sentence that accompanies that conviction. We'll talk about this in some later podcasts, I'm sure, but the problem is that we all know how harsh immigration consequences are. And we also know, some of us, I believe very strongly, that the criminal defense context and the criminal trial practice area is where persons who commit crimes should be punished, not with immigration consequences. In other words, when a trial judge sentences a defendant to serve time in jail, that trial judge has made a determination that this individual should not be on the streets. This person needs to serve some time in jail and become rehabilitated before they can rejoin society. And that's for the trial judge to decide. It is not for immigration judges and the BIA to decide using case law that basically says, okay, if you have a conviction, you're exiled from your family. You have to leave the United States. In some cases, you can never come back. To me, that is not at all appropriate. And that people who are criminals, of course, we don't want them on our streets, but the place to deal with that is in the criminal trial context. And so, the more that we can train and support criminal defense counsel to not let a defendant get into that kind of a mess in court, the better off everybody, I think, is going to be. And, there are so many complex and detailed laws and standards that are used in the immigration context to judge whether a particular crime is a crime of involving moral turpitude, whether it's a weapons offense, whether it's an aggravated felony conviction, that it's something that you really need expertise to determine. And that's why we keep emphasizing how important it is to get an immigration specialist or expert like you to advise criminal defense counsel.
So, Lory,
One thing
you've mentioned certain titles and, aggravated felony and crime involving moral turpitude. And so these are not issues that are found in a criminal statute. You're referring to the immigration statute, right? So if I'm a criminal defense attorney, or if I'm I have a criminal case and I'm curious, what criminal consequence or immigration consequences would my charge have if I were to be found guilty of it, or if I were to plead guilty? Where would I try and look and try to figure it out if I wanted to give myself that adventure, that challenge?
If you were the criminal defense attorney,
yes,
or if you were the defendant?
I mean, I guess both. They would go to a source and try to figure it out, and then they would say, "Holy cow, let me call Lory." But where would I go and at least try to figure it out?
Well, okay, I guess, I mean, to be very basic, the laws that impact immigrants and immigration cases are first found in a statute, a federal statute. Is that what you're referring to? There's a statute, and it's something that everybody could look up online, but it's almost impossible to understand. For example, the aggravated felony section is in the statute, and it lists under it, I don't know how many, 25, 26 different types of offenses that can count as aggravated felonies. But it doesn't explain which particular criminal offenses that might have been charged in a state prosecution are the ones they're talking about. It talks more generically, like it might say any crime involving a motor vehicle, or any crime involving obstruction of justice. And then when there's a criminal charge, let's say you're the defendant and you're charged with obstruction of justice in your state, just because that appears in the aggravated felony listing in the statute does not mean necessarily that the game is over, because it all depends on how your state defines obstruction of justice versus how it's defined in the aggravated felony context. And that takes all kinds of analysis that some attorneys cannot even handle. It's not something that comes easily, and there's all kinds of techniques that we have to use in order to decide by comparing the aggravated felony law to the state law, and whether or not they overlap precisely the same or whether they're really different. And that's why, you and I think, emphasize so much, and we're going to talk about this in later podcasts, how important learning these skills are. If you're an attorney who wants to be able to provide this kind of advice, it's not that easy. It's learnable. Definitely it's learnable. I don't want to discourage anyone, but it's very, very difficult. And you can't just glance at this list and then turn to your client and say, "Oh, I don't see your crime that you're charged with listed there, so no worries." Right? That will not do. That would not be considered effective counsel.
Absolutely. I think it's a lot of fun. Let's say that a client is placed in removal proceedings for a crime, and there's not enough time to get it reopened, or maybe it's not even a good idea to get it reopened, right? When you reopen a case, you're starting over, and maybe you got a good deal, as best a deal as you could have gotten without going to trial. But if you go to trial, you could be looking at a very long time. So maybe for whatever reason you weren't able to get it reopened, or it's a bad idea, or etc. There are ways, if counsel is knowledgeable enough and creative enough, and the way we analyze the criminal statute and compare it to the federal statute, we can say, hey, you know what? I think this state statute, it punishes a lot more behavior that's included in federal law. And so because of that, it's not an equivalent. And because of that, it's not a deportable offense. And therefore, the client gets to remain here in this country. Something like that. Right, Lory?
Right. Yeah, absolutely. On the other hand, let me give you an example of a case I handled fairly recently, of somebody who, when they were convicted, I think actually the charge was aggravated assault, and the way it was defined under state law, it was an aggravated felony, considered a crime of violence. And so the immigration attorney got this client when the client was set up to appear in a deportation hearing, and there was no time to do anything, and nobody denied that he in fact was convicted of this offense. So there was no relief. He had to admit that in fact, yes, he was convicted of this, and he got ordered removed. And a lot of times we'll tell people, as a matter of strategy, okay, let's take an appeal to the Board of Immigration Appeals. But in this case, it really wouldn't have been a good faith appeal, because there was, excuse me, no disputing the fact that it was an aggravated felony. He had been convicted of it. And we knew by investigating the state where he got convicted that he had not been told, he had not been properly advised that it could be an aggravated felony. But in order to make that kind of an argument in immigration court, you have to show some results from the state court. So that individual ended up getting deported. And in the meantime, we went to work in a neighboring state where he was convicted, got an attorney there, looked into what had happened in this individual's case in front of the criminal court, and discovered that he had not been advised that there would be immigration consequences. So we successfully, with the help of somebody in state, successfully got a judge to vacate that conviction on a Sixth Amendment claim of ineffective assistance to counsel. Then we had a person who had left the country already under deportation, and we had to reopen that case in front of the immigration judge because we hadn't gone to the Board of Immigration Appeals. So we filed a motion to reopen before the immigration judge, and we showed that this conviction no longer existed. And in fact, it hadn't existed arguably from its inception, the time at which it was entered, because he didn't get the good advice he needed. So we filed the motion to reopen. Guess what? The immigration judge denied it. So that case ended up taking an appeal to the BIA and getting argued in the 10th Circuit Court of Appeals.
And Lory, what was the basis for the denial? You had already vacated the conviction, right?
Yes, the conviction was vacated. And you're raising an important point, which is most immigration judges, even if you're filing a late, untimely motion to reopen, when they see that a conviction only ground for removal that existed, and it would really render this person non-deportable and non-removable, usually the judges will reopen these cases. But in this case, the government opposed it. The government argued that he had already been deported and therefore he was out of the United States. And there's a rule in immigration law that the regs require that you cannot pursue a motion to reopen if you're not in the country. Okay? Now, some courts of appeal, including in the 10th Circuit, have ruled that that doesn't matter. If you look at the statute on motions to reopen, it doesn't indicate at all that your motion isn't viable after you're out of the country. So in any case, the judge refused. We took it to the board. The board, as usual, affirmed to the judge, and we went to the 10th Circuit, and the 10th Circuit actually upheld motion to reopen, and the result is complicated, so I'm not going to go into it specifically because it's kind of dense. But the point is that oftentimes, if you have to go back to immigration court, you are going to be arguing not only the fact that your Sixth Amendment claim is one that should be recognized and acknowledged by the immigration court, but that you deserve this other chance to put your case in front of the judge. In this case, if the government had just agreed, there wouldn't have been any ground for his removal at all. And you often don't find out until the 11th hour that this was a case where prior criminal defense counsel was not effective in the slightest. So it's a very, as you can see, these proceedings are very woven together, and being able to handle this kind of complexity is really critical, which is why I recommend that somebody in this position always get an attorney to represent them. But even as we've been talking about, moving back to the whole idea of when you're charged with a particular crime, criminal defense counsel, no matter how costly it may be, no matter how busy you may be, it's critical to get an immigration expert's advice on this type of a case.
Absolutely. And some public defender offices, they actually have staff
Yes.
members who are really good at these issues, but a lot don't. So
Right.
even if you have a public defender, you need to make sure that they either have someone on staff who is excellent at this, or you have to figure out a way to get someone, okay? So they can really guide you through this. Now, Lory, let's say I'm a non-citizen and I have this issue and I'm searching on the internet and I'm finding out, holy cow, they placed me in removal proceedings now, but I found out under Padilla that I can possibly vacate or kind of reopen this conviction. But Lory, you said that it's only cases that happen after Padilla, which was 2010. So before that, am I out of luck?
Yeah, you are out of luck under Padilla. I would say, always examine whether or not there was misadvice, like we mentioned before, or there could have been other defects in the criminal proceeding that warrant reopening it, short of Sixth Amendment ineffective counsel claims. There could be other bases for ineffective counsel.
Can you talk a little bit about misadvice? Because that could be a game changer, even before Padilla, right?
Yes, exactly. So like I was saying before, if a prosecutor tells you, oh, listen, I know this area and your client will be fine, don't worry about anything, this is going to be a good plea, make sure that you check out those plea bargain offers. I would not accept that. I would say, let me check this, and I would talk to a colleague in immigration law who really, if you're an immigration attorney and you don't know it yourself, you can do some research. You can look at Board of Immigration Appeals, precedent decisions to see how certain different types of crimes are construed. There are also some really valuable tools that have been put together by different organizations. One of them is the Immigrant Defense Project in New York, for example. They have been working in this area for a long time. Another is ILRC, the Immigrant Legal Research Council, I think, something like that.
Sounds good to me.
And they put out a lot of advisories and other articles explaining what these cases mean and what to look at. They particularly focus on California law, but you can look at it and try to see how it might apply to your state. So there are resources out there, and there are also some charts that have been made by public defender offices or immigration advocates in different states. And these charts will kind of run down the list of state offenses, and then they'll show you going across the chart, would this be a crime involving moral turpitude? Would this be an aggravated felony? Would this be a domestic violence crime or whatever? And you can kind of look at it. I still would say you always want to talk to somebody. I wouldn't go solely on a chart because things get out of date and you're not really sure if it applies to your case. But yeah, and I think the main thing is you have, like you're saying, the most important thing, which we will get to in later podcasts, is you have to be able to go in there and analyze that crime and examine it to see if the elements of that crime meet the elements that are in the immigration violation that is now being charged against you, or that will be later charged against you, and make sure that they match. As you were saying before, if they don't match, if one is overbroad, for example, if the state statute allows you to be convicted of certain offenses that have nothing to do with the immigration consequence or immigration violation, then there are arguments that can be made that you can't rely only on the name of the offense, for example. And, one of the things that's so critical, it's something kind of like a mantra that I think it's important for people listening to this to know. And that is what you're looking at when you're analyzing a crime to see if it is going to match or be an immigration violation is it's the crime as defined in the statute. It's the crime as defined, not what the person did. You might know that the person went into somebody's house or they hit their mother over the head with a frying pan or whatever the actual behavior and conduct might be. That is a completely separate thing, because the reasoning for that is because if you looked only at what the offender did, you would be, in the immigration context, substituting that proceeding for the criminal proceeding, like retrying the individual. In the criminal proceeding, that person got charged with an offense. And when you're trying to decide, is this an immigration violation, what you want to look at is the crime as defined in the statute.
Exactly.
Just repeating to yourself, crime as defined in the statute.
Let me give folks an interesting example.
Okay.
So federal law defines controlled substances as several dozens, if not hundreds, of different drugs or controlled substances. But you have certain states who, in addition to those controlled substances, they also punish possession or distribution of some additional substances. And in many cases, after analyzing these statutes, and some of the federal courts have agreed, hey, because that state punishes possession or distribution of additional controlled substances that are not on the federal list, it's overbroad, and therefore that offense, while punishable under the state as a crime, would not be deportable under federal law.
Right, exactly. And that's what you were talking about earlier. It's such a interesting and challenging area to think through these things. Let me give you another example that you can think about. When I was on the Board of Immigration Appeals, of course, I did this all the time when I was looking at cases that had been appealed to decide whether, in fact, the crimes were punishable by immigration law. And in one case, the term assault means to put somebody in apprehension of a battery, meaning you get scared, someone is going to hit me or somebody's going to knock me down or whatever. And so there it's not necessary to have any specific contact, right? You can put somebody in fear of being harmed without touching them, right? And but at the same time, if you want to classify that offense in the immigration context as an aggravated felony crime of violence, you have to show that there's a possibility, or you had to show that there's a possibility force could be used. Okay, so there was an example that I read about of one case in which it took place in a prison. And, the gang leader or whatever was charged with assaulting so-and-so. And the gang leader claimed, I never touched him. I never got close to him. All the gang leader did was say to somebody else, take care of Shorty, right? so that was not,
good, Lory.
so that was not an assault. I mean, he didn't threaten to harm anybody, right? That's the immigration argument. The same thing is true if you want to think about this with poisoning. Like some people say that if you kill somebody, it's got to be a crime of violence. No. What if you poison their tea, right?
Yeah,
That's
there's
not
no force whatsoever.
no force used, unless you force them to drink it.
There
But
you go.
other than that, right. So that's how these things, a lot of it is wordplay. And a lot of judges, especially judges in the circuits and in the Supreme Court, I think, are a little bit perturbed by the fact of how much it's wordplay. But that's the way it works. That's the way the law goes. And that's what we have to apply.
Right. And it's funny, if state courts and state legislatures, if they want to make, the criminal net be able to be cast as wide as possible, and they want to make it a lot broader than federal law, they can,
Yes.
but they're also making it harder to deport people for those crimes. So, it's either you choose one or the other. So, Lory, I really think it's interesting, the misadvice concept, because if somebody's looking, wow, I have a 2008 conviction, wow, Padilla's 2010, I'm out of luck. But you have a lot of cases involving misadvice, and even from defense counsel, right? If defense counsel said, hey, yeah, I know you don't have your papers, or you have a green card, you'll be
Right.
fine.
Right.
Right? You'll have a green card, you'll be fine. This will not get you deported. That's misadvice, and they could potentially try to reopen it on that basis, no?
Yes. However, that is misadvice, and you could make a sort of Padilla-like argument without citing Padilla or relying on Padilla.
Yeah.
You could say, this was my attorney, and she owed me a duty of effective counsel, and she explicitly told me not to worry about XYZ, right? And I followed that advice, and look what happened. So yes, even though Padilla itself is not retroactive, so you can't cite it as an authority from the Supreme Court, you can make up your own case in which you're pointing to the elements that later went into Padilla. And so I do think that misadvice is an area where you can try to make an ineffective assistance claim. There's another case that's really important, and criminal defense practitioners are aware of it. It's called Strickland versus Washington. And Strickland has a kind of a two-part standard for showing prejudice based on ineffective counsel. And so you have to not only show that the misadvice was given, but you have to show with some certainty that I wouldn't have taken the plea, for example. I would have gone to trial. And you have to show, or I would have taken the first plea that I was offered, but you advised me not to take it and to go to trial. And then later, when I was losing at trial, they offered a worse plea with harsher terms, and I was stuck accepting that. So there is a necessity to show prejudice and be able to do so with some convincing evidence.
Well, I mean, this is just a sneak preview into just how complicated this area of the law can be. You're talking about dealing with several different attorneys, criminal defense, immigration, counsel, and crimmigration, and the intersect. But for lawyers like you and I, we personally find it fun and challenging, and it's really rewarding when you can really save somebody's life in doing this. Because I mean, like the Padilla court said, the Supreme Court said that this is not just a mere collateral consequence. This is banishment. Some of these crimes under immigration law can result in permanent banishment. And these are people that some of them came here when they were 3 years old. So the consequences can be dire. But we enjoy working on them. And when you're able to either, get the conviction vacated or argue that the statute of conviction is overly broad and save them from deportation, it's really gratifying.
Right. And we'll be talking about that kind of overly broad statute and how to analyze them and arguments that you can make in later podcasts. I know I'm excited about doing that.
Me too. It's a lot of fun. We'll break it down for you guys. So I guess you're going to have to stay tuned. Lory, thank you so much again for sharing your wisdom.
You're welcome. It was great fun.
All right, guys, we'll see you next time. If you have any questions, get in touch and be good to yourselves and each other. I think I quoted Jerry Springer, but I'll see you again. Take care, everyone. Bye-bye.
Bye-bye.